This is Karen Harding, lawyer, continuing along with the report that I was writing and have written on the community justice model for Otara, Therapeutic Jurisprudence and Action, a case for a community court in Otara. Just skipping along now to the conclusion. And I'll go back and do some videos of the guts of it to show where I get the information to design my proposal. So my proposal is about a community justice solution for Otara. In my view, therapeutic jurisprudence is the critical element missing from the New Zealand courthouse and justice experience. It is the key element to reducing New Zealand's #1 problem of recidivism, and if adopted would more effectively deliver justice and improve public perceptions of justice. The Baisley report on the review of the legal aid system recommended the courts should do more to reduce recidivism and to deal with underlying problems leading to offending. Dame Baisley urged the court to make the most of teachable moments in dealing with first offenders, and that alternatives be found for the charging, prosecution and imprisonment of low-level offenders. The report recommended using a case management system to address defendants and their families' social deprivation. It also recommended that wraparound services be provided to families and that assistance be provided to get people into employment. To effectively achieve change and to address the concerns raised in the Baisley report, an effective approach would be to utilise and apply therapeutic jurisprudence, and along with the other new tools available in the Justice Toolbox, applying these, in my view, in a community justice context using integrated service delivery systems in a collaborative manner. In my view, that would make the difference. In my view, we could get at the heart of this justice problem and address what Dame Baisley is saying if we utilised and applied therapeutic jurisprudence using the new tools available in the Justice Toolbox, which I've got separate videos on to explain, and did it in a community justice context with integrated service delivery systems and used a collaborative manner. B, the proposal for a Otara Justice Centre. This is my proposal. The establishment of an Otara Community Court and Justice Centre, applying the principles of therapeutic jurisprudence, community justice and problem-solving justice techniques, targeting local needs, would be more effective at responding to crime more promptly and holding offenders accountable to the local community. It could be constructed to engage the support of locals and to provide integrated social services, applying a whānau-centric approach to case manage low-level offenders, aiming to prevent further offending by providing services to assist with family social deprivation, counselling and treatment for alcohol and drug abuse, and linking offenders, victims and their families into government and other agencies. This would go a long way to addressing the concerns raised by the 2009 Baisley report. It would allow for a joined-up governmental response to provide a pathway out of offending and an alternative to the current approach of dealing with low-level offenders that would allow an alternative to imprisonment. A community court approach would make meaningful interventions in people's lives, addressing underlying social problems that contribute to offending, ensuring restitution to their community for the harm caused to it by their offending, and sending out a clear message that the rule of law matters, while at the same time meeting rehabilitative and family needs. Neighbourhood policing initiatives in Otara would be greatly enhanced if a community court was established in Otara with a community prosecutions team. Subchapter: a multicultural courthouse experience to address cultural needs. This is my proposal and vision. An Otara Justice Centre should be set up near the town centre, near parking facilities on a site developed in conjunction with Maori. This would be an improvement to the Manukau District Court, which does not provide parking and creates difficulties for court users. The Otara Justice Centre should also contain a healthcare centre with an emphasis on providing educational activities and counselling support for the children of court users. This would address one of the criticisms in the Baisley report concerning the current setup of district courts such as the Manukau. This will give court users a safe place to bring children while attending at the Justice Centre, and also link the children into educational programs and social services. The Justice Centre should be family friendly. A key feature of a community court is that its physical setup and operating style should be inviting, not intimidating, and it should be safe. Subchapter: a broad court jurisdiction with innovative courtrooms. I propose that to deal with the underlying identified issues of concern in Otara, such as graffiti, truancy, family violence, drug and alcohol issues, youth offending, and reentry issues, which we're talking about parole, that lead to offending in the Otara community, that the Otara Community Justice Centre should be modelled on the Red Hawk Community Justice Centre. This would involve an establishment of a multidisciplinary courtroom, setting across boundaries of criminal and family jurisdiction, presided over by a judge empowered to deal with summary prosecutions, i.e. not jury trial stuff. The presiding judge at this community court would handle offences occurring within the local Otara area. These would be prosecuted by an Otara Community Police Prosecution Section, supported by an Otara Neighbourhood Policing Team, who are policing the local community. It could also deal with tenancy and housing issues with decentralised branches of the Tenancy and Disputes Tribunals and the Family Court, as this was identified as being a community need in Otara. As well as a focus on the criminal jurisdiction, the proposed Community Justice Centre Community Court for Otara could deal with protection orders, custody and access issues, and other family law matters. The court could develop an innovative family court treatment room to deal with participants appearing before the court, that's i.e. your offenders, we call them participants, appearing before the court whose legal issues and other problems cross criminal and family court boundaries. A family treatment courtroom would allow family violence prosecutions, protection order applications, custody and access issues, skilled truancy problems, rehabilitation and other housing issues facing a family in the Otara area to be considered and resolved in a holistic manner. A decentralised branch of the family court should be set up to mesh with the family violence court, similar to the approach in the Harlem Justice Centre and how that centre looked across judicial issues and made it easier for the courts to monitor and assist vulnerable families, and we could do this in Otara to help them. The judge could adopt an integrated approach for dealing with family and criminal issues where these problems cross over, particularly in relation to domestic violence cases. This could be achieved by providing support to victims and sending the offender on courses to be monitored by the court, along with monitored drug and alcohol treatment and monitored relationship counselling. Such intervention may be helpful in stopping further violence from occurring in the home. It would allow the court to quickly and more effectively respond to breaches of protection orders. The court would have available to it the full sanctions of the criminal justice system and cut red tape relating to family court matters. The Otara Community Court Judge, in my proposal, could be supported by a local community magistrate for dealing with lower quality of life crimes such as willful damage caused by graffiti and other offences carrying punishment within their jurisdiction. This could follow the approach of sending offenders out into the community to restore the damage done by painting over graffiti, working on landscaping projects, sorting recyclables and assisting the Salvation Army and local churches, cleaning the city centre and other projects as suggested by a community board set up to support the court to provide innovative sanctions to encourage offender accountability. As a further sanction, an offender on community service detail could wear a distinctive vest indicating and reflecting their offending, making community service assets visible in the community, and hopefully acting as a future deterrent. I then propose using specialist courtrooms in Auckland. The first court type I propose, so these are just like within the existing courtroom you just run a court on an appointment time during that day in that room. I call it attendance court. An attendance court could be set up with local truancy issues to deal with those problems. This can be based on the model set up in the East Harlem and in Brooklyn. Truancy court aims to hold children and their families accountable for school attendance. This is an effective strategy for dealing with chronic absenteeism, which if left unchecked leads to criminal offending. The attendance court can provide intensive supervision by a person in authority to encourage school attendance, educational achievement, and deal with the underlying issues contributing to truancy, such as poverty, problems at home, and health issues. This is achieved by linking children and youth into social services, encouraging those struggling academically, and by providing mentoring through a coordinated approach. The program would have no power to punish, but would provide an occasional tough talk and could be delivered by utilising a retired judge who would conduct review hearings with the child and their family every fortnight. The second court I propose is a teen court to encourage youth accountability for low-level offending. The Otara Community Court and Justice Centre, in my vision, could establish an innovative special youth court where teenagers, being young future leaders of the future, resolve cases involving their peers. This could be set up following the model at the Red Hook Justice Centre. Local youth in Otara could be trained to be advocates, jurors and judges for the teen court. Cases could be referred to it through referrals from the police and the schools. This would more effectively hold young people accountable for antisocial behaviours, and young people in crisis could be identified at an early age and linked into support and counselling services provided through the centre. It works really well in Red Hook and helped to resolve neighbourhood problems with youth before they get to a serious stage. So they're not getting convictions, they're sort of getting managed with their own peers really and being held accountable. The third type of courtroom I propose is a re-entry court. This is to do with parolees. There could be a re-entry court to intensively supervise persons released on parole in the Otara area. Like the re-entry court at the Harlem Neighbourhood Justice Centre, the parolee would be brought to the courthouse before being released to meet with their parole officer to sign and go over their release conditions and release plan. They will then appear before the presiding judge to have their conditions publicly outlined in a forum that encourages family attendance to be followed by regular court monitoring of their progress on their release plan. This is important because some parolees are returning to Otara after serving sentences for serious crimes, and this would provide more intensive supervision than a traditional system. A re-entry court will better assess parolees with their reintegration issues, and they can be linked into social services to support them and training courses with local iwi support. It is envisaged that the parolee will be linked into wraparound social services, and for those who are not immediately entering pre-arranged employment, they may be provided with vocational support, sent on training courses, and for those with alcohol and drug problems linked into treatment, both residential and outpatient, to progress and monitor them over their period of parole. And that would be judicially monitored. For those released after a murder conviction, this means they will be intensively managed for life. The re-entry court at the Otara Community Court and Justice Centre could also be used to intensively manage returning sex offenders. I also propose a fourth court, which I have called the Healing to Wellness Courtroom. Tribal drug courts such as the Healing to Wellness courts have been adapted for Native American and Alaskan Native communities. These special courts have allowed these communities to take ownership of the drug court concept. The Murri Court, MURRI, was also developed to meet these needs of the Australian Indigenous population. These tribal courts could be further adapted and translated into the New Zealand and Maori setting. Adapted to encompass a Maori worldview to provide culturally appropriate legal services where Maori offenders would benefit from a drug court approach with a Maori flavour. This would involve investment in evidence-based programs about what works for Maori that embraces positive cultural features. The Ministry of Maori Development in iwi, along with the Manukau Urban Maori Authority, could be involved as partners in planning this initiative to develop a wellness courtroom to improve Maori outcomes from the criminal justice sector. Maori are seeking whānau-led local responses, initiatives and programs designed by Maori and delivered by Maori with practical interventions based on understanding diverse Maori realities. The Otara Community Court and Justice Centre could develop such a program and a specialist courtroom utilising a partnership basis, whānau, hapu, iwi and Maori community leadership in conjunction with a community board set up to advise the court, the Ministry of Justice and other social service partners. Positive benefits were seen from using the marae in the eastern suburbs of Christchurch after the Christchurch earthquake as a criminal court setting. Those using the marae reported that it has worked extremely well, stating that there is a case for making it a permanent fixture. What was seen as a positive was that the Ministry of Justice brought the court to the people rather than the people having to come to the court. It is in their patch and they know their patch and they deal with it accordingly, is a quote from a source material I quoted. It was observed that the majority of people using the court were Maori and they exhibited a sense of pride in the Murri Court and the marae that was set up during the earthquake in Christchurch. This could be used as a blueprint to deliver justice in Otara and around New Zealand. Justice data reveals that only 27% of youth dealt with in the Maori marae courts reoffended compared to a 51% recidivism rate in the mainstream youth court. The difference was that a marae-based approach enabled youth to reconnect with their culture. And further chapter, an integrated services model required for the Otara Community Court. The Otara Community Court and Justice Centre, in my proposal, would work in a collaborative partnership with treatment and social service providers and support workers. A funding partnership with the Ministry of Health would be constructive to provide professionals with the building to screen and assess court participants for drug and alcohol abuse issues and to provide reports to the court as required. A WINS customer service located within the centre would be of assistance to assist vulnerable people, and representatives from iwi trust providers such as the Manukau Urban Maori Authority should be available to assist whānau. Salvation Army and other social service providers such as LifeWise should also be involved to assist the court participants and whānau. The centre can link into iwi support services through the government's proposed Whangiora scheme, which provides wraparound services. The Manukau Urban Maori Authority is one of 8 consortiums to be funded to support families. Their program should be developed in conjunction with the Otara Justice Centre that I propose. This would allow Maori a significant voice in justice issues in Otara and in rehabilitating their people. A concerted effort needs to be made to lift children of Otara out of poverty and to encourage them to achieve at school. Reducing child abuse will help achieve that goal. A wellness service should be set up at the Otara Justice Centre, providing services to victims and other vulnerable persons with appropriate programs to provide anger management counselling, courses for developing self-esteem, and recovery from family violence and abuse. It is envisaged that this service will also provide health services and should be free and accessible for members of the Otara community to utilise. My next chapter is titled Servicing the Legal Needs of Otara, an Integrated Public Community Law Centre. To service the legal needs of offenders, litigants and participants at the Otara Community Law Court, the local Otara Community Law Centre should be further resourced. With an Otara Community Public Defence Scheme. This is my vision. They would provide a full range of integrated legal services to service the community court, including criminal, family, civil and customer protection advice. It would also assist to meet the needs of the Pacific Island community in an area to provide immigration and related advice. The Otara Community Law Centre should adopt the integrated legal service delivery model of the Neighbourhood Defender Service of Harlem, using a holistic defence team approach in servicing their clients, adopting whānau-centric ethic of care principles to the legal problems of Otara residents. The defenders, which is the lawyers, should be tasked not only with defending criminal charges, but also dealing with the collateral consequences faced by their clients. This would be similar to the service offered by the Public Defence Community Law Office of Knox County, Tennessee. In my vision, the Otara Community Law Centre should provide their clients also with access to counselling, mental health services, literacy, life skill classes, budgeting, parenting skill classes, job counselling and access to vocational training and assistance to obtaining driver's licences. This would provide a wraparound service. They should also be involved in community outreach to provide early intervention, educational programs and mediation services. I also go on to provide some additional plans for this centre. And also talk about a not-for-profit private legal services for Otara residents. As well as a community law service with a dedicated public defence for Otara, the community would also benefit from the establishment of a private defence and legal services provider operating for a not-for-profit basis, providing both legal and integrated social services. This could be set up through a charitable trust to provide holistic defence services, meeting the needs of those outside the catchment area of the local public defence service, as not everyone will be eligible to legal aid and many will require ongoing support after a criminal case has concluded. We've got to remember people using the public defence lawyers are on legal aid, but not everyone gets legal aid. Sometimes they just slip through the cracks, but they can't also afford a lawyer. This private defender service would set up along the model set up by the Georgia Justice Project and the Bronx Defenders. This service would be further expanded to assist returning parolees and their clients with obtaining employment. This could be achieved through setting up associated not-for-profit companies providing employment such as labouring, landscaping, painting, services to the community, and to also provide an income, uplifting their clients out of welfare dependency and providing work experience. The final subchapter is headed Expanding Consortiums to Engage Legal and Social Services. The government is setting up partnerships with consortiums such as the Manukau Urban Maori Authority to provide wraparound services to whānau for issues such as domestic violence and alcohol and drug addiction. Other consortiums such as the Waipirapa Trust also provide medical and health services to their communities and tutoring services for children attending local schools to lift Maori educational achievement, and have developed a computerised database linking services from their trust's health, welfare and educational arms. I'm proposing that if the consortium servicing Otara moved into providing qualified legal services with experienced lawyers able to serve the local community court, and also provided health services, vocational training in addition to their current advocacy, educational training, literacy and social services, then Maori would benefit by receiving culturally appropriate legal, health, welfare, education and social services in an integrated one-stop shop. This would enable the residents of Otara to begin to lift themselves out from the effects of addiction, poverty, family violence, gangs and recidivism. This would make the Otara community safer and empower local people. So I've read out the paper to you. I've got to do the extra chapters with the middle in it for you to read out, but that puts together a whole proposal to deal with this problem with Maori crime and to make communities safer and to help everyone and increase well-being. This is really a better proposal which we could do for every community in each district and the towns that need special issues attended to, so we don't have to spend so much money on prisons and stop crime and help people. So this was Karen Harding, lawyer, Auckland, New Zealand.